Lamb's Chapel was kind of the sleeper. It was an important case and grew in its importance as time has gone on. There, a church simply wanted to share a film series about family values in the evening with the citizens of its community, and they were rebuffed. They were told that content of the film was a violation of a policy, that you can't have, quote, church-related information being given out at a school facility.
The school district here has adopted a policy that states that social, civic, recreational uses and other uses pertaining to the welfare of the community can take place. They've made the affirmative determination that, in fact, those type of activities can take place. A school district could close its facilities. They're not being compelled to open them.
Doesn't political speech fall into that category?
I believe it does. That's what I was saying to you. The question here is not whether political speech can take place, because under the policy, political speech can take place. The exclusion is if it's from a partisan organization, and I think that suffers from constitutional defects as well. Let me make the position, what we're saying is this. The school district here has elected to open its facilities as they've conceded to a wide diversity of uses. They have targeted the religious purpose speech for exclusion. They have conceded that the religious exclusion in our case is based on the perspective of the film series and its religious nature. That's their concessions. Once you have a governmental municipality organization opening up its facilities to social, civic, recreational uses and other uses pertaining to the welfare of the community, they cannot then close it because of a religious perspective.
Is your theory, Mr. Sekulow, that you cannot pick on religion? That if religion is just one of many things excluded, it's okay?
No.
But if it's the only thing excluded, or one of only a couple of things excluded, it's not okay?
My position is, this is my position, that when you open up when a school district elects to open up its facilities for community use, for such uses as social, civic, and welfare of the community needs, you cannot exclude religious
Why?
perspective.
Because that includes too many needs?
No, because the religious perspective is relevant to civic concerns.
Oh.
And that's where the viewpoint discrimination is here. And I think the record in our case points that out quite clearly.
But they haven't said civic concerns. They've said civic concerns except religious concerns.
Now, actually,
don't
precisely what they've said is we are allowing outside, not-for-profit groups to utilize school facilities under our access policy for social meetings, for social, civic, recreational purposes, and other uses pertaining to the welfare of the community.
But they haven't stopped there, and they've said except religious.
Right. And that's precisely our point. That is the type of viewpoint discrimination.
Yes, why? Because they've singled out religious...
Yes, they have targeted religious speech for exclusion in the nature of the entire facilities that they've opened up.
But you would not mind if they singled out religion for exclusion along with a lot of other things. That is, they said we're going to allow bowling.
That's
nothing else. We're not going to allow religion. We're not going to allow politics. We're not going to allow other socially good things. You wouldn't have an objection then, would you?
No, but that's the type of subject matter restrictions that a school district in this type of situation, certainly they could say just for tenants.
Why is that okay and this one not okay?
Because here they have opened up the facilities intentionally for social, civic, and welfare of the community.
No, they haven't. They've said social, civic, and welfare except religious.
But that's what they cannot do, however.
And you say they cannot do it. Why can they not do it?
Because this court has said that viewpoint discrimination, even in a non-public forum, is not acceptable. And I don't think that's...
But you've just said viewpoint discrimination is acceptable if they say we're going to have bowling, but we're not going to have...
I guess the argument could be made if there's a religious perspective on bowling. But when you open up the topic and the subject matter to social, civic, and welfare of the concerns, and I think the record points to this. There's two things that I think are extremely important with regard to the record. Family Counseling Services, which was an organization that utilized the facilities for counseling, dealt with precisely the same issues that the school district would have dealt with, that the church would have dealt with in its film series.
You also said that they could not exclude religious services, didn't you?
I think under the policy that they've adopted, they cannot.
We won that case unanimously, and then a whole arena, if you will, of litigation exploded. A policy said you could not have sectarian or religious discussions or worship in senior citizen centers throughout the United States. It was now declared unconstitutional by the U.S. Court of Appeals for the 10th Circuit. The reason why? Lamb's Chapel. So clearly, Lamb's Chapel had broad import.